Hey everyone, Harry here to talk about tomorrow's hearing before Judge McAfee in Fulton County on severance motions. It's actually going to be pretty important. So point one, McAfee says to Fani Willis something that no one has required her to do so far. Normally, when you schedule cases and talk about the dates, both sides have to explain how long their case is going to take. And Fani Willis hasn't had to do that so far. She's just proffered different beginning dates. Yeah, we can do this November 3rd, or yes, let's do this in March. But she came to fame with her RICO litigation, including one she personally was lead counsel for, involving a whole scandal down in Atlanta about teachers kind of falsifying test scores and the like. That case, it started out with a whole bunch of defendants. They winnowed down somewhat, I think, to about 8 or 9, which we can expect this to do. Then they tried the case, and it took only 8 months to try. And I think like 3 months in addition to pick a jury. So, she's going to have to come in good faith and say, here's how long it's going to take. And maybe she says 3 weeks on my side, but I don't see how. On the other hand, if she says something like, well, we think it'll be 4 months, like no one's really thought about that yet. And that's going to blow everything out of the water. So that's point one. Point two is I've referred to it sort of on the fly here and there, but it's time to really focus on the difference between severance on the one hand and removal and speedy trial on the other. So Chesbro and Sidney Powell come before McAfee tomorrow in this hearing. Chesbro, recall, right away moved for a speedy trial. Really what he was doing was wanting to sever. But severance, as I'll talk about in a minute, isn't automatic, whereas speedy trial is. So he thought he was sitting kind of pretty. I've referred to it in this, lifeboat. But now here comes Sidney Powell, not the person you really want to be in the lifeboat with. And guess who is starting to rappel down the rope to the lifeboat? John Eastman. So all three of them are going to move for, the two of them have moved for speedy trial. Eastman's going to. And now Chesbro's clever idea doesn't look so clever, because the idea, I think at first, was he wanted to be on his own. And sort of distinguish from the other folks, maybe point the finger at them. That worked when it was just he, but now it's also Powell and Eastman. So now we come to severance, and that's what McAfee is going to take up tomorrow. And here's the thing about severance. Well, one more preface. Without severance, it's a little unclear for removal. It's totally clear for speedy trial. Unless and until defendants sever out, they're together. They're a group. So right now, there's a trial set to begin no later than November 3rd, and pick a jury even before that. That's Chesbro and now Powell. And everybody's in that same boat, because there's no one who's been severed out. And that means they're all, part of the one trial date that has been set. And indeed, Fani Willis has said we should try them all 19, and try them starting, late October, picking a jury, and November 3rd. And here's the rub. Severance, which usually defendants want and prosecutors don't, is not automatic. Indeed, there are sort of 2 or 3 factors a court has to consider. A court has discretion, but has to consider 3 factors that basically equate to 3 paradigms for getting severance. The biggest, most likely one is if there's a piece of evidence that's going to really prejudice a defendant that would not come in, and except for his being or her being at the table with the other defendant. It's admissible against the other defendant. Typically, a judge could say only considered against the other defendant. But if it's a really big, say it's a confession or something, a judge can instruct a jury, but it's understood a jury can't ignore that. That's the big paradigm. Second is if there's so many that it's really confusing about the law and the facts. But that's the whole point about the RICO here. It's the same law and it's the same facts for everyone. There's a lot of them, but she's going to prove the same thing to all of them in theory. That doesn't seem a very good fit. And then finally, antagonistic defenses, but it's not. Even mutually inconsistent defenses don't cut it. The Supreme Court of the United States, as well as the 11th Circuit, has made clear it's basically got to be a thing where it's such sort of opposing stories that the jury is at a loss to even make a basic guilt or innocence determination. I don't see it here. They, whatever Chesbrough's going to say, whatever Sidney Powell's going to say, I think a jury can decide. So this is a puzzle that McAfee, I think, has realized he has, and he's got to figure out, and that's the hearing tomorrow. Point one is to get Willis to say how long it's going to take. But point two is to figure out whom can I sever and how. It stands to reason that he knows it's really pushing it, let's put it that way, to force everybody to go to trial November 3rd. Indeed, Donald Trump has made a motion to sever, saying, I just don't have time to prepare. That's just too fast. But guess what? That's not a recognized reason to sever. And he could be saying, you'll violate my due process rights. That doesn't really hold up either, because they're not violating Chesbrough's, they're not violating Eastman's, they're not violating Powell's. They're going quick for sure, but the if it were a violation of due process to go that quick, then the Georgia Speedy Trial Act would be unconstitutional as applied. So he's got to figure out a way. I mean, I think in a perfect world, he would want to sort of methodically make a few batches of defendants. Which batches will those be? He's right now not sure, Judge McAfee, because he wants to know who's going to try to remove and who's going to try to go quickly and where will Trump be and who's going to try to point the finger at Trump. This may actually force defendants to kind of show their hand at least halfway in a way that'll be really informative to us. But McAfee, if he's a good and honest judge, he's very young. Maybe a little bit, well, we don't know yet how, if he's up to the task, but the basic problem, the puzzle he's got to solve is there's nothing about the removals. There's nothing about the speedy trials that really give a good excuse for severance. So tomorrow, again, to sort of finish this preview, what's Fani Willis going to say about how long her case is going to take? That's first. And then second, where will McAfee be going in terms of trying to carve up the case? Because the way to do that, except by speedy trial motion or removal motion, what's left to him to do is by severance. And at least the reasons that have been put before him by the various defendants, they're not very good reasons under the law. Now, if he makes a mistake here, he might be thinking, judges often do in criminal cases, that if a defendant wins, they can't try him again, and it's double jeopardy. And if he loses, it's sort of the end of the story. So he might be thinking, I can carve these up. The prosecution won't be crazy about it, but they won't appeal, and it'll be sort of pushing on the law. That might be part of, his calculation, but we'll see, because as I say, right now, from what we know, severing is, on the one hand, feels like it's got to happen to some extent, but on the other, doesn't seem to fit with the law of severance as we know it. So that's going to be the drama, along with Fani Willis's revelation of how long her case is going to take at tomorrow's hearing at 1:00 East Coast time in Fulton County. Talk to you later. Thanks for tuning in. If you enjoyed this video and other Talking Feds content, please take a second to like and subscribe. Talk to you later.